Um, a very good evening to everyone present here. May I request everyone to kindly take their seats? We are about to begin the launch ceremony of IBCmantra, the law and practice of Insolvency and Bankruptcy Code, authored by Senior Advocate Mr. Tarun Gulati and Advocate Kumar Sambhav. I would first request Mr. Gulati and Mr. Sambhav to invite our guests of honor, our chief guests and our guests of honor to the dais, please. Honorable Mr. Justice Vikram Nath, Honorable Mr. Justice Manmohan, Honorable Mr. Justice Sanjeev Sachdeva, Honorable Chief Justice of our High Court, Justice Devendra Kumar Upadhyay, Honorable Mr. Justice Sudhanshu Dhulia, and Mr. N. Hariharan, President of the DHCBA. We are also delighted to welcome Honorable Justice Ashok Bhushan, Honorable Justice Pankaj Mittal, and all the judges of the Honorable High Court who are present here. May I first request everyone to rise for the national anthem. Thank you. Please be seated. It's my great privilege to welcome all the honorable judges, learned senior advocates, members of the bar, and distinguished guests to this special occasion. Today marks the launch of IBC Mantra, a free and open online commentary on the Insolvency and Bankruptcy Code dedicated to the members of the bar. The project seeks to make legal research and commentary more accessible, accurate, navigable, and useful for practitioners, students, judges, insolvency professionals, and the wider legal community. I take a minute to introduce the authors of the commentary. Mr. Tarun Gulati, as many of you know, is a senior advocate based in Delhi for the last 3 decades or so. He's a qualified chartered accountant who switched to legal practice early in his career with specific focus on fiscal and financial laws. Designated as a senior advocate in 2019, he continues to shape the practice in these areas with his extensive appearances before various forums, including the Honorable Supreme Court and High Courts and tribunals across the country, as well as his academic writings. His co-author, Mr. Kumar Sambhav, is a graduate of ILS Law College who qualified as an advocate in 2017. He joined Mr. Gulati in his chambers in 2019, after which he has continued to extensively practice in taxation, commercial laws, and insolvency laws, and has been appearing before the same forums. His keen interest in academic pursuits, along with Mr. Gulati, has culminated in them co authoring the law and practice of insolvency and bankruptcy code in India. Before we proceed further, we would like to felicitate our esteemed guests and express our gratitude to them. I'd first request Mr. Nitesh Mehra to present a planter to our chief guest, Honorable Mr. Justice Vikram Nath, as a token of our gratitude. I'll now request Ms. Chandrika Gupta to present a planter to Honorable Mr. Justice Manmohan. Now request Ms. Ruchika Sharma and Mr. Rohan Sharma advocates to present a planter to Honorable Mr. Justice Sanjeev Sachdeva. I'd like to now call upon Mr. Amit Chaudhary and Mr. Shresh Rawat to present the planter to Honorable Chief Justice Devendra Kumar Upadhyay, please. Next, I request Ms. Shruti and Ashom Shandilya to present a planter to Honorable Mr. Justice Sudhanshu Dhulia. I'd like to finally invite Mr. Shivom Sethi and Ms. Kriti Narula to present our token of appreciation to Mr. N. Hariharan, President of the DHCBA. We shall now begin the program. It is my pleasure to invite Senior Advocate Mr. Tarun Gulati, co-author of this commentary, to deliver his introductory remarks.
Thank you, Ronnie. I'm actually truly overwhelmed to see so many honorable judges of the Supreme Court, judges of the High Court, senior advocates, and my friends at the bar to be here on a working day, busy working day, to have taken out time for this. The panel, the Honorable Chief Guest, Justice Vikram Nath, graciously grateful to you for having accepted the invitation. Likewise, Justice Manmohan, Justice Sanjeev Sachdeva, the Honorable Chief Justice of Delhi High Court, Justice D.K. Upadhyay, Justice Dhulia, who actually wrote the foreword, and he was the one who initiated all of this, and and Mr. Hariharan, without whose cooperation this wouldn't have been possible. The kind of support that Mr. Hariharan has given me in organizing this and making it and graciously accepting it on behalf of the bar is really commendable. I'm thankful to all of you. And I can start by saying that when the bar and the bench, they come into one room, it is not just an event, it becomes an occasion. And for Kumar and me, it is truly a momentous occasion. It's going to be a highlight of our lives. I know that for all the people in this room, time is a scarce commodity. And so thank you for spending that time with us. All I can say is that we've tried to make this event tight and the proceedings brisk. We've just kept 5 minutes slots so that of course will lead to less deliberation on the subject, but given constraints of time on a working day, that's how it is. Firstly, about the structure of the book. The way the book was conceived, we tried to do a commentary section wise rather than theme wise, because that's how lawyers operate. We were told by our seniors, never look at case law first, look at the bare provision. So the commentary actually sits next to the bare provision. First look at the provision, see what comes into your mind, and then start reading. So that's how the book is conceived. We always feel that lawyers don't read books like scholars. They rather read it like a locksmith reads a lock. They try and see what fits in where. And that's how the commentary is conceived. And the decision to make it online, while we from the previous generation, I call myself the previous generation because ultimately the future belongs to the young members of the bar. In the last 15 years in my chambers, I have not seen any junior colleague actually, unless coded, pick up a hardbound volume and research. Today, all research, practically all research has become online. Two decisions we took deliberately. One, to make it online, and two, to make it open source. Two reasons. One, the kind of information that is available online today, and with AI coming in, just about everything is online. And I think this is the future. While the traditionalists will continue to say that unless I hold the book, the hard copy book in my hand and turn the pages, I don't absorb knowledge. But I think we need to move with technology. And that's why the decision to make it online was taken. To make it free for the bar. I think the future is this. I think the manner in which publications are made, it is about time that people started creating legal content and making it available to the young members. Otherwise, what will happen is that what I feel is that knowledge can never hide behind a price tag. The younger members of the bar, the student community, all of them need access to rich content which they need not afford. So this is the first first thing that we have done. I'll just come to the second part of it to say that we are planning some other initiatives as well to help younger lawyers and students. But for the moment, let me say how this was conceived. When I got designated in 2019, I came from a firm background. I didn't have an office of my own, and I was not in the counsel market. I really didn't know whether I'll get any work or not. I didn't have furniture, I didn't have books, I didn't have a library. My father's library sat in Allahabad. I didn't have staff, and I got a knock on my door from my co-author, Kumar Sambhav. He said, I wanted to join you. I said, I don't know where I'll get work from. So he told me that I have just conceived a book on IBC. I'm writing it. I'm willing to take the risk. And if you don't get any work, at least we'll be able to write the book together. It so happens that we did get a substantial amount of work, and the book actually took 7 years because of that. But I'm grateful to him for having invited me to co-author this book with him. IBC was not my subject. I did it out of academic curiosity with him. Another reason which drew me to this work was that very early in my career, my father had just retired as a High Court judge in 1998, and I had got an offer to write a supplement of a very celebrated author, a law book, and my father started helping me with that because he had refused all post-retirement jobs. He was a person, I would say, he was known for quiet diligence. He would shun away any spotlight. Today, with his photograph in the backdrop, I think he wouldn't have agreed to this. He'd never taken credit for any of the work that he did. Today, I thought we should give it to him anyway. That work didn't get completed for reasons beyond our control. And I thought that the circle has to complete somewhere, and this was an opportunity for me to at least put my name against one authorship and dedicate it to him. This book actually is not just dedicated to him. My co-author is rather shy. His father, late Mr. Rakesh Sharma, he lost his father quite early in life. And I think I would have loved to have the second photograph on that side. But Kumar didn't, of course, for reasons which are very personal to him, didn't say that. But I dedicate this book to his father. So the book is actually dedicated to both our fathers. Next, I say that when in this profession, I think it is common to all lawyers that we have no life other than work. The biggest sufferers are our families. The biggest sufferers, oh, well, they might also say.
Mr. N. Hariharan, President, and Mr. Vikram Singh Pawar, Honorary Secretary, to kindly officially accept copies of the book from the authors. I now invite Mr. Hariharan, President, Delhi High Court Bar Association, to kindly address the gathering.
Honorable Justice Vikram Nath, Judge Supreme Court of India and a distinguished chief guest, Honorable Justice Manmohan and Honorable Justice Sanjeev Sachdeva, Supreme Court of India, judges of the Supreme Court of India, and our own, if I could say that, Honorable Justice Devendra Kumar Upadhyay, Chief Justice, Delhi High Court, Honorable Justice retired Sudhanshu Dhulia, former judge, Supreme Court of India, Tarun Gulati, learned senior advocate, Kumar Sambhav, learned advocate, all my colleagues, learned senior advocates, members of the bar, insolvency professionals, academicians, ladies and gentlemen. A very good evening to all of you. On behalf of the Delhi High Court Bar Association, I extend our warmest welcome and gratitude to our distinguished judicial guests for honoring this occasion with their presence. A legal work launched within the precincts of a court is more than a publication. It represents a continuing conversation between legislation, judicial interpretation, professional experience, and legal scholarship. The platform unveiled today, IBCmantra, the law and practice of insolvency and bankruptcy, brings all these elements together. The history of insolvency law is in many ways the history of society's changing response to commercial failure, if I may so say. Older legal systems treated default almost as a moral delinquency and concentrated upon pursuing and punishing the debtor. Modern insolvency jurisprudence proceeds upon a more mature understanding. Insolvency is not necessarily wrongdoing, and commercial failure cannot always be treated as culpability. The law must remain stern against fraud, diversion, and misconduct, but it must also remain intelligent about genuine business failure. The modern question is therefore not merely how much can be recovered from the debtor. It is also, can a viable enterprise be rescued, employment preserved, value protected, and capital returned to productive economic use? The Insolvency and Bankruptcy Code 2016 did not merely consolidate laws, it changed the grammar of commercial distress. It moved from individual enforcement to collective resolution, from debtor control to a creditor-driven process, from indefinite proceedings to statutory timelines, and from liquidation as a natural consequence of default to revival as the preferred objective. Having said that, equally, speed cannot mean haste, and procedural fairness cannot be converted into interminable delay. The genius of the code lies in maintaining these balances. Having said that, a commentary which unites law with practice must therefore take a lawyer from the statutory text to its governing principle, and from that principle to an effective remedy. IBCmantra is an appropriate title because the work seeks to distill complexity into guidance without diminishing its legal depth. What makes this initiative particularly meaningful is that it is free, open, and dedicated to the bar. Free access does not diminish the value of scholarship, it multiplies its reach. For a young advocate or an independent practitioner, access to a reliable commentary may determine whether a legal instinct remains an institution or becomes a properly supported proposition before the court. A bar is only as strong as its youngest well-prepared member. And knowledge is perhaps the only professional capital that grows by being distributed. I remember an old saying in Malayalam. It says, Kuduthal yera vardikyam vidya, which essentially translates to this that this is the only wealth which increases by giving. So I welcome this great proposal from Tarun, and I'm thankful to them that they thought about the members at large when they started authoring this book. May this platform unveiled today carry sound legal thought from this auditorium to every chamber, tribunal, and courtroom where it can illuminate argument, clarify the law, and ultimately serve the cause of justice. Thank you so much.
Thank you very much, Mr. Hariharan. We have already heard that Justice Sudhanshu Dhulia had given the foreword for this commentary, and so it would be appropriate that I now invite Justice Dhulia to address the gathering now.
Justice Vikram Nath, the chief guest of this function, Justice Manmohan Singh, Justice Sanjeev Sachdeva, Justice Vikram Nath, I said. Sorry. Justice Manmohan, Justice Sachdeva, Justice D.K. Upadhyay, and the Chief Justice of Delhi High Court, Mr. Hariharan, the President of the Bar, Tarun, Honorable Judges of Delhi High Court, members of the Bar, and ladies and gentlemen, members of journalists, media fraternity, and of course, the family members of Tarun and Kevin. Actually, it gives me great pleasure to be here in this function today because the book which is being released is on an important subject, Insolvency and Bankruptcy Code, and it's being written by two young lawyers with a lot of effort. See, as we all know, this code was enacted with a purpose, and the purpose was to bring the entire fragmented law on the subject at one place, to consolidate laws, to reorganize them, to give the best value of the assets, to promote entrepreneurship rather than to discourage it, to streamline the procedure, fix a timeline, so on and so forth. And to a large extent, at least when it was initially enacted, it looked that it was solving its purpose. And it's for this reason that one of the earliest occasions the Supreme Court had to comment on this statute in, I think, innovative industries case, Justice Nariman had said that it's a path-breaking legislation. It's a paradigm shift in law. That's what he said. But any law is as good as it's there. It's merely a skeleton and flesh. And as the noted jurist Aharon Barak has said that the life and blood through a statute is given by the interpretations. And so by now we have several interpretations on various aspects of the law. I'm sure these authors have compiled all those and done a great effort to do it. There are other books on the subject. But the unique thing about this book is that it is easily and freely available to all of us. So that's good part of it. Now, a little bit about the authors, and particularly Mr. Tarun Gulati, because before this function, we were there in the green room, and I saw a lot of former judges and the sitting judge, our Chief Justice also, lot from Allahabad. So it brings all the old memories of Allahabad also. I know the Tarun and Kevin for the last more than 25 years, since Allahabad days. Tarun comes from a family of lawyers and judges. Both his father and grandfather were judges of Allahabad High Court. In fact, I had an occasion to meet his grandfather after his retirement, because I was very friendly to his uncle, who was with me in school and then in the university and then as a lawyer. So I met his grandfather at that time. And then, of course, I appeared before Justice R.K. Gulati on a number of occasions. It was so pleasing to be with appear before him. I'm sure he's not here today, but I'm sure he'll be very proud of the achievement of his son since this book has come out. And I really wish both the lawyers, Kumar Sambhav, the name is very unique, because when I saw this name, it immediately struck me that his parents or whoever is given the name to him must be either a Sanskrit scholar or a great admirer of Kalidas, because his name is unique. And I also remember that in the, bringing the old memories, Tarun's house is on a very famous road in Allahabad called Edmundston Road, as those who are from Allahabad would know. And every morning, I'm talking about late 60s and early 70s, when I was to go to my school. So on the left-hand side, there was a landmark place, which was the place where Northern Indian Patrika, the leading newspaper of Allahabad, was being published. And just across the road was this great bungalow of colonial style bungalow of Tarun and his ancestral house. And I used to say, "Kaun rehta hoga in bade makanon mein?" That. But later on, he became his uncle. I said became a very good friend. And then Tarun, I knew when he used to come to, not in Allahabad so much, but because he must be a student then. But when I shifted to Nainital, then he came on some occasions to Nainital, and he briefed me a few cases, and I knew how hardworking he is. So best of luck to them. Best of luck to him and Kumar Sambhav. Let there be more books, and all free of cost. Thank you so much.
Very sincere thanks to Justice Dhulia. Let there be more books and all free of cost. I shall next invite Chief Justice Honorable Mr. Justice Devendra Kumar Upadhyay to kindly address the gathering now.
Honorable Mr. Justice Vikram Nath, Justice Manmohan, Justice Sanjeev Sachdeva, Honorable Judges of Supreme Court of India, my esteemed sister and brother judges of High Court who are present here, Justice Ashok Bhushan, Justice Pankaj Mittal, Justice Dhulia, former judges of Supreme Court, Shri Hariharan, President of Delhi High Court Bar Association, and other office bearers, members of the bar, authors of the book Tarun and Kumar Sambhav, ladies and gentlemen. Tarun spoke about his father, Justice R.K. Gulati. So when he came to invite me for this function, I just shared with him an anecdote related to his father when he used to hold court at Lucknow. Justice Gulati, most of the time as judge, held his court at Allahabad, but in the year 94, 93, 94, 95, he was seated at Lucknow, and I had an occasion to appear before him. I didn't know Tarun earlier. I know his elder brother, Kavin. I don't know whether he remembers or not. In his senior's chamber here in Delhi, I have some occasions to brief his senior, not to come in. I must also share a secret. I, as Judge of the Allahabad High Court, has been somehow instrumental in getting him designated as senior advocate. My single vote might have worked in his favor. So, I mean, in those days, the designation used to be by voting. So, and then once he was designated, he vanished from Allahabad. A very good evening to all present here. It is both an honor and a privilege to be present at the launch of this important commentary on insolvency and bankruptcy laws in India. I was just weighing the weight of the book, so I could immediately realize as to why this book has been made available online as well. So this is to discourage to go through the book. I extend my heartfelt congratulations to the authors, editors, and publishers for producing a work that promises to enrich legal research and professional practice in one of the most dynamic areas of commercial law. The Insolvency and Bankruptcy Court represents one of the most significant economic and legal reforms in independent India. It fundamentally altered the approach to financial distress by shifting the focus from prolonged recovery proceedings to timely resolution, preservation of enterprise value, and balancing the interest of all stakeholders. Since its enactment, the code has evolved through judicial interpretation, legislative amendments, and regulatory refinements, reflecting the adaptability that every modern commercial law requires. Success of any legal framework depends not merely on the text of the statute, but on the quality of its interpretation, implementation, and continuous academic engagement. The IBC has generated a rich body of jurisprudence from the Supreme Court, the National Company Law Tribunal, and National Company Law Appellate Tribunal. These decisions have clarified complex issues relating to commercial wisdom of creditors, treatment of operational creditors, avoidance transactions, cross-border insolvency, and role of insolvency professionals. A legal system thrives when practitioners and scholars engage in constructive dialogue. Commentaries such as the one we launched today play a vital role in fostering that dialogue. They bridge the gap between theory and practice, explain emerging trends, critically analyze judicial decisions, and provide guidance to lawyers, judges, bankers, insolvency professionals, corporate executives, researchers, and students. Importance of insolvency law extends far beyond distressed businesses. A credit insolvency framework enhances investor confidence, improves access to credit, strengthens financial institutions, and contributes to sustainable economic growth. It reassures entrepreneurs that while businesses' failure may occur, the legal system provides an orderly mechanism for resolution rather than endless litigation. This philosophy aligns with the broader objective of improving the ease of doing business while ensuring fairness, transparency, and accountability. At the same time, every reform presents new challenges. Questions relating to delays in resolution, maximization of value, cross border insolvency, group insolvency, treatment of personal guarantors, and emerging issues arising from technological and financial innovation continue to shape the future development of insolvency law. These challenges underscore the importance of rigorous research and informed debate to which this publication makes a valuable contribution. I congratulate the authors for their dedication and intellectual effort. Writing on a subject that evolves so rapidly requires not only expertise but also perseverance. I'm confident that this commentary will become a valuable reference book for courts, tribunals, practitioners, policymakers, and academic institutions. I also compliment the publisher for bringing out work that will strengthen the literature on commercial and insolvency law. Publication of this nature contributes significantly to capacity building within legal profession and help cultivate a deeper understanding of evolving insolvency ecosystem. As we formally release this commentary, let us also reaffirm our commitment to building a legal framework that promotes responsible entrepreneurship, protects stakeholders, and supports economic resilience. The continued success of India's insolvency regime will depend on collaboration amongst the judiciary, the regulators, the professionals, academia, and industry. On this occasion, I once again congratulate everyone associated with this venture. I wish the platform every success and hope it stimulates meaningful discussion, further research, and informed practice in the years ahead. Thank you. Jai Hind.
We are thankful for the kind and supportive words of Chief Justice Devendra Kumar Upadhyay. I shall now invite Honorable Justice, Mr. Justice Sanjeev Sachdeva, Supreme Court, to kindly address the gathering.
Well, normally one begins with salutation, but I will begin by saying it's good to be back. Mr. Justice Vikramnath, Judge Supreme Court of India, Justice Manmohan, Judge Supreme Court of India, Mr. Justice Devendra Kumar Upadhyay, Chief Justice High Court of Delhi, Mr. Justice Ashok Bhushan, Justice Pankaj Mittal, Justice Sudhanshu Dhulia, former judges of the Supreme Court, my colleagues from the Delhi High Court, Mr. N. Hariharan, President of the High Court Bar Association, authors of the book Tarun Gulati and Senior Advocate and Kumar Sambhav, senior advocates, members of the bar, family members of the Gulati family. Think about a vibrant and healthy ecosystem. For life to thrive, old and decaying matter must efficiently clear away to return nutrients to the soul, to the soil. For decades, the Indian economic system lacked this vital clearing mechanism. Entering a business was celebrated, but exiting a failure one was a nightmare. Entrepreneurs were trapped in failing ventures, capital was locked in unproductive assets, and banks were weighed down by bad loans with no clear resolution in sight. Justice Dhulia just now quoted Justice Nariman that this act was a paradigm shift. Everything changed in 2016. The introduction of the IBC marked a tectonic shift in India's economic history. It replaced a fragmented, century-old framework with the single unified law. To truly appreciate the impact of IBC, we must understand the chaos that preceded it. Before 2016, India's insolvency framework was a patchwork of overlapping archaic laws. We had Sikh Industrial Companies Act, the SICA, the SARFACI Act, the recovery of debts due to bank financial institution. This fragmented system created massive loopholes. Cases dragged on for years. By the time a company was liquidated, its assets had eroded to a fraction of their original value. We are still suffering from some cases which are still pending liquidation. There are several in the high courts. The old regime suffered from a fundamental philosophical flaw. The debtor remained in possession. A promoter could default on thousands of crores of bank loan while maintaining complete control over the company. Creditors were left begging at the gates, fighting through endless litigation. and this created severe non-performing assets. Crisis crippled the business banking sector. Now, the paradigm shift, which we talked of, was introduced, it completely changed the center into a creditor in control concept. The moment a company defaults and enters the corporate insolvency resolution process, control shifts from a defaulting promoter to an independent professional. The most revolutionary aspect of IBC is strict timelines. The time-bound mechanism prevents asset stripping, mining, and preserves the economic value. A common misconception is that IBC is a corporate death warrant designed to shut down companies. It is not. The primary object of IBC is resolution, not liquidation. Liquidation, in fact, is the last resort. The code views a company not just as a collection of building and machinery, but as a living entity that provides employment, pays taxes, and contributes to the GDP. The goal is to rescue the corporate debtor. Through the Committee of Creditors, financial institutions evaluate resolution plans submitted by prospective buyers. Companies handed over to a new, financially sound management team capable of reviving it. This saves jobs, protects supply chain, ensures the economic engine keeps running. Since its inception, IBC has achieved remarkable milestones. It has completely altered the consumer and corporate behavior. IBC has a very powerful behavioral effect. The fear of losing control over a company has forced promoters to become more disciplined. Thousands of debtors have settled their defaults before the IBC notices are issued or before the matter reached the NCLT. It has globalized India's business reputation. IBC was a driving factor behind India's historic leap in World Bank ease of doing business. Despite these monumental successes, journey of IBC is an evolving one, and we must be candid about its challenges. We need to strengthen the infrastructure. One step towards strengthening infrastructure is what we just saw today, an online launch of the book. Digital infrastructure has to be upgraded. Commercial wisdom of Committee of Creditors has to be improved. Government has been proactive, but we as stakeholders have to be more proactive. This commentary would no doubt be an educative and an enriching guide to all the stakeholders in performing their respective responsibilities more effectively. I congratulate both the authors and wish the book a great success. Thank you very much.
Thank you, Honorable Mr. Justice Sanjeev Sachdeva, for highlighting the significance of this commentary in the context of today's financial regime. I shall next invite Honorable Mr. Justice Manmohan to kindly address the gathering.
Respected Justice Vikramnath, my brother Justice Sachdeva, Chief Justice Upadhyay, former judges of the Supreme Court, Mr. Dhulia, Justice Pankaj Mittal, Justice Bhushan, my batchmate from faculty, Mr. Hariharan, my brother and sister judges from this court, with whom I spent a very long time in this court, the authors, Mr. Gulati, Mr. Kumar, and my colleagues at the bar, distinguished ladies and gentlemen, and including the Gulati family. When I was practicing as a lawyer, I used to feel that the most lucrative side of practice is the commercial law. And in those days, commercial laws used to be practiced in 4 major forums. One was the company court, where the winding up would take place. The second was the company law board, where there would be operation and mismanagement petitions. The third was the DRT, DRAT, where the recovery proceedings would take place. And then there was IFER and BIFER, where you would go under the Sick Industrial Companies Act. And amongst these corporate laws, the most lucrative was IFER and BIFER. That is the Sick Industrial Companies Act. It was an absolute irony that the sicker the company, the higher the fee. And I soon realized that the lawyers who go to IFER and BIFER go on the longest vacation and the best vacations. So I was really tempted to go to these forums, and I used to practice quite a bit there. Now, all these forums have virtually merged into one, which is NCLT and NCLAT. Therefore, they have become very powerful tribunals, very important tribunals. And you have a new act, which, as many of my predecessors have pointed out, that there has been a paradigm shift in the insolvency law, and things have changed for the better. It's very challenging law. It's a new law. It's only been 10 years since this new code has come into force. It is an evolving law. When you contrast it with other laws like the Indian Contract Act, which are more than 100 years old, where the principles of interpretation have been settled, this is still a law which everyone is grappling with. And every time when an IBC matter is heard in court, there's a new dimension attached to it, because it is a law that is growing and that is challenging. So I'm very happy that Tarun as well as Kumar have taken up a challenge to write about the IBC. I'm also happy that Tarun has stepped out of his comfort zone, that is the indirect taxes, and taken up this challenge to write about IBC. I say that because it's very courageous on his part to venture into a new field, a new subject. And there is also a good dimension to it, that whenever a person of a high intellectual standard applies his mind to a new subject, he always brings in fresh thinking, which helps in the growth of law. And I'm sure this volume will help in the growth of law in this field. I am also happy that they're sharing their labor of love free of cost with the entire bar. That, I think, is a very positive development. They need to be applauded for that. And I hope this sets a new trend. And lawyers who are doing well decide that it is time to give back to the profession what they have earned. And there can be no better way than giving back or sharing knowledge with the next generation. When we were youngsters and joining the profession, the only issue or the challenge that we used to face was that, do I have a good library? And the first generation lawyers would always say that the only thing missing is that I don't have a good library. Today, people have unfortunately stopped reading books. They only read and gather information what is available on their mobile or on their laptop. So I'm glad that this book has been put on the net so that the youngsters will have good access to it. Access is very important. Access to knowledge is very, very crucial. And I think in the coming times, what will matter is whether we have access to good knowledge or not. So I'm very happy that this book will be available in digital form, easy to search, easy to locate whatever you are searching for. And this is a great way, as I said, of paying back to the society. And I encourage more and more people, especially the people who are doing well in the profession, to write on new subjects, to bring in fresh thought and fresh knowledge. I wish them the best and thank you very much.
Thank you, Honorable Justice Manmohan, for your kind words about the utility of this project. I'd like to now invite our chief guest, Honorable Mr. Justice Vikram Nath, to kindly address this gathering.
A very warm good evening to everyone present in this auditorium. My esteemed colleagues, Brother Justice Manmohan, Justice Sachdeva, Chief Justice of Delhi High Court, Honorable Mr. Justice D.K. Upadhyay, Honorable Judges of the Delhi High Court, former Judges of the Supreme Court, Justice Ashok Bhushan, Justice Sudhanshu Dhulia, Justice Pankaj Mittal, former Judge, Allahabad High Court, Justice Dilip Gupta is here, learned senior advocates, members of the bar, the authors of the IBCmantra, Mr. Tarun Gulati and Mr. Kumar Sambhav, Tarun's elder brother, Mr. Kavin Gulati, call him always Kavin, and family members of the Gulati family, young lawyers, ladies and gentlemen. Book launches are, of course, professional occasions, but every now and then they become personal as well. This is one such event for me. It gives me great pleasure to be here for the launch of IBCmantra, the law and practice of insolvency and bankruptcy. I have known Tarun for many years. I have also known his elder brother Kavin equally well. It has been heartwarming to watch both of them grow in the profession, each in his own way, and earn the respect of the bar through hard work and integrity. Seeing Tarun's name on the cover of a serious work of legal scholarship does not come as a surprise. It feels like the natural culmination of a long, arduous journey. Talking about this journey, I cannot but mention late Justice R.K. Gulati. Whenever I meet Tarun or Kavin, I am reminded of him. For those of you who don't know, Justice Gulati was a judge of the Allahabad High Court. He was a very different kind of a judge. He was a quiet man. I still remember how those of us who appeared before him often used to remark, almost in disbelief, on how little he spoke. He was extremely patient. He used to run his court in a very different manner, mostly sitting on the tax side. My own courtroom, as many of you know, runs rather differently. His interventions were few, but they invariably went to the heart of the matter. Justice Gulati possessed a degree of patience, and I admire greatly. Some of my fondest memories are not only from his courtroom, but also from his huge bungalow on the Tashkent Road now. Earlier it was at Johnston Road, number 10. I always enjoyed visiting there. There was always good conversation, good humor and hospitality. Looking back, now those evenings remain among my happiest memories in Allahabad. That generation of lawyers and judges believed that the law was not merely something to be practiced. It was something to be shared. Looking at IBCmantra, I feel that it belongs to that same tradition. And that's because the authors have chosen to make this book available to the bar free of cost. It is often said that knowledge acquires more value when it is shared. That is true of every profession. It is perhaps even more true of ours. The legal profession is built upon the collective efforts of generation of lawyers, judges, and scholars. Every young lawyer benefits from someone else's labor, a reasoned judgment, a good paper, a senior willing to explain a difficult point, or a commentary that brings clarity to an evolving era of law. Writing such a book requires an enormous investment of time and effort. Those are hours that could easily have been devoted in doing something else or maybe something better. To then place that work in the hands of the others without expecting anything in return reflects a generosity of spirit and deserves recognition. This spirit is perhaps appreciated most by those of us who entered the profession at a very different time. Young lawyers today have access to everything. An entire library now finds inside a laptop. I still sometimes find it amusing how quickly information travels today. You say something in court, sometimes even in passing, and before you even reach home, it is everywhere. It has found its way into Twitter, Instagram, LinkedIn, and every other platform. When we entered the profession, information moved very differently. For every question we had, library was the answer, and there was usually one copy of the book everyone wanted. If someone had borrowed it before you, that was the end of the matter. You either waited or you tried your luck with the librarian. No doubt the research took longer, but it was not really a disadvantage. We ended up reading far more than we had intended to. Quite often, while searching for one proposition, we came across another that turned out to be even more useful. Those accidental discoveries were among the great pleasures of legal research. Technology has transformed the way we work, and unquestionably for the better. But one thing has not changed. The need for good legal scholarship remains exactly the same. Information is available in abundance. What is much harder to find is perspective. A good commentary does not merely tell you what the law is, it explains why the law has developed in a particular direction. What are the principles? That is what makes such works indispensable to both the bar and the bench. I believe IBCmantra will serve precisely that purpose. The Insolvency and Bankruptcy Code is still a relatively young statute, yet in the span of a decade, it has fundamentally reshaped the landscape of commercial law in India. Every few months, there is a fresh question before the courts, something the statute did not anticipate, or a provision that two benches have read differently, or an entirely new situation that was not anticipated. What a book like this does is take all of that development around the law and give it some order. It tells you not just what the sections say, but how they have actually been read and applied, where the courts agree, where they don't, and where the ground is still shifting. It is through without being exhausting, and it does not waste the reader's time. With that being said, I would not like to say something about the authors. Tarun hardly needs an introduction before this audience. Over the years, he has built a distinguished practice in tax, regulatory, and commercial litigation. He is also certified chartered accountant. This, combined with his experience at the bar, gives him a perspective that is both practical and analytical. He understands not only the legal framework of insolvency law, but also the commercial realities within which it operates. Kumar Sambhav has, in his own right, established himself in tax and commercial litigation, appearing before courts and tribunals across the country. Together, they bring complementary strength to this work. Ultimately, as I said before, the development of the law is a shared enterprise. By writing this book and by choosing to place it freely in the hands of the profession, Tarun Gulati and Kumar Sambhav have made a contribution that extends well beyond this evening's launch. I congratulate both the authors on this fine achievement. I wish them every success, and I wish this book the wide readership that it richly deserves. Thank you very much.
Thank you, Honorable Mr. Justice Vikram Nath, for your kind insights and wishes. As the final item of today's program, I invite Mr. Kumar Sambhav, Advocate, co-author of this commentary, to deliver the vote of thanks.
Good evening, everyone. Thank you. It is my privilege to propose the vote of thanks on this very special occasion. At the outset, I express my deepest gratitude to Honorable Justice Vikram Nath for gracing this event as the chief guest. There is a rare clarity, warmth, and force in your Lordship's words. For members of the bar, it is always a pleasure to hear your Lordship speak. I am equally grateful to Honorable Justice Manmohan and Honorable Justice Sachdeva. Both your Lordships have a deep and affectionate connection with the Delhi High Court bar, and the members of the bar have always held your Lordships in the highest regard. I also thank Honorable Justice Devendra Kumar Upadhyay for his kind words, gracious presence, and support. I must express my special gratitude to Honorable Justice Sudhanshu Dhulia, who has not only graced today's occasion but has also been kind enough to write the foreword to this commentary. I am also deeply grateful to the Honorable retired judges of the Supreme Court and the Honorable judges of the High Courts who have taken out time to be present with us today. Honorable Justice Ashok Bhushan has contributed immensely to the development of insolvency jurisprudence through thousands of decisions under the IBC. Honorable Justice Pankaj Mittal has authored several important judgments while serving as a judge of the Supreme Court. The presence of so many honorable judges of the Delhi High Court and other high courts, despite the demands of a working day, is deeply encouraging, and we are sincerely thankful for all for taking out the time to grace the event. Justice Kameshwar Rao, Justice Nitin Samre, Justice Mehta, Dinesh Mehta, Justice Pratibha Singh, Justice C. Shankar, Justice Jasmeet Singh, Justice Amit Bansal, Justice Manmeet Arora, Justice Amit Mahajan, Justice Anish Dayal, Justice Om Prakash Shukla, Justice Tejas Karya. From the Delhi High Court, we are grateful that you are here. Justice Dilip Gupta, who's the former chairman of Central Excise Service Tax Appellate Tribunal, and he's the current chairman and the former judge of the High Court of Allahabad. He has also here. Thank you for your presence, sir. I'm deeply grateful to Mr. Tarun Gulati, Senior Advocate. Sir, your guidance, patience, discipline, and faith in this project made it possible for this work to reach this stage. For me, this commentary is not only an academic project, it represents years of learning, discussion, and work under your guidance, and I remain deeply thankful for that. My heartfelt gratitude to the Delhi High Court Bar Association for supporting this book launch. In particular, I express my gratitude to the President, Mr. N. Hariharan, and Honorary Secretary, Mr. Vikram Singh Pawar. I also thank Mr. Nitesh Mehra, Mr. Amit Chaudhary, Ms. Chandrika Gupta, and all volunteers who helped in organizing today's event. I must also thank Mr. Shailendra Kumar from Tax India Online, our knowledge partner, for guiding us with his immense experience in organizing such events. I must convey special thanks to the editorial team and contributors who gave life to this commentary. Shruti, Akash Tuteja, and Jayant Sharma made substantial contributions at different stages of the work, and the work would not have been possible without the valuable contributions made by them and by all the other contributors who stepped up at different stages of the project. This commentary is openly available online, and therefore dissemination is as important as publication. I'm grateful to the members of the media who have joined us today and who have helped and will help in taking this initiative to a wider audience. I also thank all learned senior advocates, members of the bar, legal, academics, students, insolvency professionals, and friends who have made time to attend today's event. This is a working day, and I'm particularly grateful that you chose to spend this evening with us. A special thanks to all the friends who have traveled from outstation to be here today. Your presence has made this occasion memorable for us in a very personal way. Finally, I thank our families, friends, colleagues, and well-wishers. A work like this is never written by the authors alone. It is carried by the patience, encouragement, and quiet support of many people around them. Thank you, your lordships. Thank you, everyone, for your presence, patience, and encouragement. Thank you.
Finally, congratulations to my dear senior Mr. Tarun Gulati and my dear friend Mr. Kumar Sambhav for this successful launch of this book. This brings the formal launch ceremony to a close. High tea will follow. We request all guests to join us kindly for the high tea. Thank you. Thank you all for your presence.